Okay, folks, let's get started. We've been talking about individual defendants and their individual lawyers. Now we're going to zoom back for a broader look and ask about the decisions that jurisdictions make at the system level. How is it that a state government or a local government goes about matching that individual defendant with an individual lawyer? It's a system question, and jurisdictions have several different choices. We'll start with this. It's a big, expensive, important government service. In the typical state court system, indigent defense accounts for more than 3/4 of the defendants flowing through the felony courts. So what are the possible ways to connect all of these defendants to all the lawyers that they're going to need, and to do it in a reasonable time frame and at a reasonable rate? Got a few choices. First of all, there's the public defender system. These are full-time employees of the government whose only job it is to deliver defense services. They are assigned some portion of the docket, typically the lion's share of the docket, and they draw a salary. They're not paid by the case. They're not paid by the hour. They're just paid a salary, and they handle whatever caseload comes to them from the courts. There are two different subtypes of these public defender systems. Some of them are funded and governed at the local level. So a particular city will decide, in our county, the defendants who go through state court here will have to first get their lawyer from the local public defender's office. In other places, it's a statewide system, and the state legislature steps in and says, we'll fund this. It's a constitutional obligation, and we'll create local offices all over the state, but we'll create a statewide quality control structure, governance structure. It's possible you could split up the funding and the control. You could have state funding and local control, or vice versa. But typically, funding and control go together so that the locally controlled offices are also locally funded and state-controlled, state-funded. The second system choice available to state or local government is appointed counsel. This is a system where the judge will counter a case, and the judge will appoint some member of the local bar. In private practice, part of this lawyer's caseload will come from appointments from the court. Typically what happens is that lawyers put themselves on a volunteer list. They put themselves on the local appointment list, and the judge just runs through the list. Sometimes there are special qualifications for certain kinds of cases. So very serious felonies, perhaps you can only get on that list if you have a certain level of prior experience with serious felonies as a second chair at a trial. These appointed counsel systems could be just ad hoc. The judge just appoints, and you hope it all works out because several different judges are appointing and they're all drawing down on one fund for the payment of counsel. But then in another system, there's an administrator where there's some kind of quality control over the names that go on the list and some kind of real monitoring of the budget. That administration might come from, say, a chief judge, or it might come from the clerk's office, or sometimes it comes from the public defender office. They are the keepers of the gate in terms of lawyers who go on the appointed list. And finally, the third category, and the one that's least commonly encountered, would be contract services, where a government will put out for bid perhaps some portion of the docket, the juvenile cases, for instance, or the misdemeanor cases, or they might put out the entire docket and say, we'll take bids. And private law firms could make the bid. Very often, public interest law organizations are formed for purposes of making bids on these contracts. And so the legal organization will agree ahead of time, this is the rate that we'll take for covering this chunk of the docket. Typically, it's not a per case rate, it's a flat rate. It puts some risk on the winning bidder. Typically, you see jurisdictions that combine two or more of these options. The most common would be some combination of public defender service to take a portion of the docket, supplemented by appointed counsel. That's the system we've got in the federal courts. It's often true in state courts. And most commonly, the appointed counsel take the conflicts cases, the cases where the public defender has a conflict of interest, maybe in multiple defendant cases, or if there's a conflict between the defendant and one of the chief witnesses for the prosecution or something along those lines. There may be other settings where the public defender only covers certain types of cases, and it's not just conflicts cases that go to other lawyers, but perhaps very serious felonies like the murders don't go to the public defender office, perhaps because they just take up too many resources, perhaps because the local bar lobbied to keep the murder cases because they're the most visible and lucrative form of business. Public defenders work in 49 different states. That doesn't mean that they work everywhere in those states. Many states have public defender offices that are only covering some of the counties or other local jurisdictions within their borders. And as between the split between the locally controlled PD offices and the state-controlled PD offices, it's roughly equal, slightly more, about 27 out of the 49 are locally administered. They run a total of 530 local offices. They employ more than 10,000 attorneys, median of 7 litigating public defenders per office. And then there are 22 states where there's a single office that runs all the public defender locations around the state. They are responsible for 427 local offices. They employ a total of about 5,000 attorneys. That gives you, I hope, a menu of options that local and state governments have when they are trying to decide how to deliver defense counsel. Also, I hope you've got now a sense of when governments tend to choose one menu item versus another, when they choose one option rather than another for delivering counsel. Now we'll talk about some more unusual situations where parties go to court to try to force the government's hand to either choose some other method of delivering counsel, or more commonly to pump more money into the system, whatever system they have chosen. So we'll talk about that when we get to the next.